C-13, an act for the substantive equality of Canada's official languages. This is it. This is the federal government finally putting forward a bill that has a fair chance of success in getting through the legislative process to modernize the Official Languages Act and to do some other things, which we'll talk about in a second. The bill is in process of second reading right now. It's in front of the House again today for further debate at second reading. After which, of course, it'll go to committee and then the report stage, and then off to the Senate. So I'm just going to give a brief overview or timeline of how we got here over the last. It's been over a decade. My first job at the PPC or at the QCGN when I started here in 2009 was to attend the 40th anniversary of the Official Languages Act, where they were talking about modernizing the Official Languages Act. So that's how long ago this whole process goes back to. Back in 2009, there were efforts that originated out of the Senate to modernize the Act, and their focus was on Part 4 of the Act. I said there were other things, but that was really the focus. And Part 4 is communications and service to the public. Those reforms were eventually realized through regulatory reforms. So the new official language or the new regulations around the Official Language Act were updated. And then in 2016, there was a sense in the official languages world, well, okay, we've sort of done what we can to Part 4. Now what else do we want to do? And the focus really then became on Part 7. Part 7 of the Act is the advancement of English and French, and it's always been a very problematic part of the Act. It comes into the Official Languages Act in the late 80s, and there's always a problem with that part of the Act because it's not very clear. There's nobody really in charge of it, but it's a very important part of the Act to us as official language minority communities, because this is the legal or the legislative tool or that through which government policies and funding and stuff go on the federal side to support our communities. So it's a very important part of the Act. The Senate picks it up again, this idea of moving the Act forward, modernizing the Act, and there's a huge study that many folks on the call or on the webinar today were probably a part of, that went from 2017 to 2019. It was a huge study that the Official Languages Committee at the Senate undertook. And in 2019, we were all feeling pretty good about where we'd arrived. We were the French linguistic minorities outside Quebec and English-speaking Quebecers were agreed on a way forward. We had consensus around our common positions on how to move the Act forward. The federal institutions were on board, and there were rainbows and unicorns everywhere on modernizing the Act. All to do was get the minister at the time, Minister Joly, to actually write the Act, get it before Parliament, and get it updated. And then the 2019 federal election happened. And in 2019, Quebec, because the provinces were also consulted, and Quebec sent a letter to Ottawa and said, this is what we would like to see in a modernized Official Languages Act. And this completely changed the calculus of all of the work that had been done since 2009 to 2019 on getting to that common ground, that consensus between the French and English OMCs on a way forward. The landscape completely changed. So in 2020, the speech from the throne from the new parliament, the Liberals come back with a minority. And that speech from the throne has concepts in it that are, to this point in the history of the Official Languages Act, 1969, foreign. The idea that official languages rights would be territorialized. There would be different rights in different parts of the country. There was the idea of asymmetry, and I'll let Marion talk about that before. In the law, in law, English and French have always been treated equally. So if you give a right, if you create language rights, those language rights are created for French-speaking Canadians and English-speaking Canadians. Suddenly this changes, so that new rights will be created only for the French language. And the purpose of the Official Languages Act is now changed. The idea is now changed as well. And this comes out in the discussion paper that comes out in 2021, that the point of the Official Languages Act will not be to breathe life into the official language obligations under the Constitution, but a purpose of the act will be to protect and promote French. Not that the act hasn't always done that or contributed to that, but this would be a specific codified, written down point of the Official Languages Act. So this changes everything. C-32 comes out in the last parliament. It dies on the order paper. The government comes back. And when the government comes back, it promises, while it's on the hustings, to bring C-32 in some form back within the first 100 days. Horrible, very American thing. Of its new mandate, which it does. And I'm just going to throw in another little piece of the puzzle here. While all this is happening in 2019 and 2020, 2021, remember what's happening in Quebec. So in the summer of 2019, the more nationalist, well, the OQLF publishes a couple of reports that the nationalists, some of the more fervent nationalist newspapers in Quebec, interpret to mean that there is a decline in French in Quebec. And this is huge. So that all these old language worries and concerns are sort of brought up again, bubble up. Why is this happening? It's happening because we are now, the groundwork is being laid for the introduction of Bill 96 by Simon Jolin Barrette. So there's a wave of populist nationalist press that comes in advance of Bill 96. Important to know there's two conversations happening at the same time using the same language, which is why this is very confusing. The number of people speaking French as a proportion of total population outside of Quebec is declining. The number of francophones in official language minority communities, as currently defined outside Quebec, is declining. So outside Quebec, there is a decline in the use of the language as a proportion of the population, and there is a decline in the number of francophones as defined by the federal government. In Quebec, there is a decline of mother tongue francophones because population growth is due to immigration. But the OQLF reports that trigger all this in 2019 make very clear that there is no decline in the use of French in the public space. But the statistics, you can play with statistics, right? Lies, damn lies, and statistics. And the political orthodoxy now, it's orthodoxy. You can't argue with it. You can't present facts to it. It simply is. The orthodoxy is that there is a decline of the French language in Canada and Quebec. And notice that specific, notice there's a specific difference there, that their two geographies are separated out. There is a decline of French in Canada and Quebec. That's the federal line now, first time ever. And this is the sort of air, this is the atmosphere, this is the environment that we're living in right now, as C-13 is presented last month, and will go to committee soon. So enough talking for me, and I'll hand over to Marion.
Thanks, Stephen. In case this is your first webinar or you haven't met me before, my name's Marion Sandilands. I'm a partner at Conway Baxter Wilson in Ottawa, and I serve as a legal counsel for the QCGN on a lot of language rights and constitutional matters. So I've, needless to say, been quite busy over the last 10 months or so. I'm going to talk about some basic principles of the OLA just to set us up. And I'm going to talk a little bit about what we saw last spring with C-32, and then now what we see with C-13. I'm going to describe Bill C-13, but I'm not going to speak to the QCGN strategy. I see some Q&A coming in about that. So just to be clear, I'm going to talk about the bill itself. And then there should be time for Q&A afterwards, which Stephen will moderate, I think. So getting started, I want to talk about the OLA in a nutshell, because there's a few things to understand about the Official Languages Act that make it kind of special and different from the Charter of the French Language, and that frame the discussion that's to follow. So 4 things. First, the OLA is highly symbolic. This is really important. It's the legislation that declares that Canada has 2 official languages. It declares the equality of status of those official languages. And that was even before the Charter came in 1982. It recognizes official language minorities in every province and territory by the very basic structure of the Act. So this is really important for all official language minorities, and particularly English-speaking Quebec, as to be recognized as a minority. And it declares that government policy is to, among other things, support those minorities. As Stephen said, the Act right now it's symmetrical. So it treats English and French in an identical fashion throughout. And it also applies the same way everywhere in Canada. That's important. The other thing about it being highly symbolic is that it may be primarily symbolic. So it seems to create a lot of obligations on the government, but at the end of the day, a lot of these seem to be more symbolic or declaratory rather than like legally enforceable obligations that you can get a court to actually enforce. The second thing I want to say about the OLA is that it has to do with federal institutions. So it regulates things in federal institutions. So that's the federal government, federal courts, tribunals, and certain crown corporations. That's its reach. And as Stephen said, Part 7 is the part that creates the framework for federal support to official language minorities and also just official language policy in general. So that's support coming from the federal government. From the perspective of the OLMCs, and that's the English and French minorities, the problem with the Official Languages Act has always been that these obligations on these federal institutions and the support that comes from them weren't specific enough, they weren't enforceable enough. And it really depended on the political will of the government of the day, whether they wanted to take official languages seriously or not. And if they did, they did, but if they didn't, they could pare back. And there wasn't really much that the official language minorities could do, legally speaking, about that. So the modernization impetus had a lot to do with, could we make the Official Languages Act a little bit stronger, have more teeth, as they say, and more enforceable. The third point I want to make is that the OLA is very, very different from the Charter of the French Language. They have a completely different orientation. There's a lot I could say about this. 2 points I want to make. First, the Official Languages Act does not restrict the use of other languages. That's not its orientation. It's very positive about the use of it, creating rights for users of a language without restricting the use of other languages. And the second point is the OLA right now doesn't create any rights or obligations outside of federal institutions. So what I mean is it doesn't apply in the private sector, except for crown corporations and organizations that have been privatized, like Air Canada. Those are the exceptions, but generally speaking, it doesn't apply in private businesses. And finally, the OLA does not get amended very often. And that actually brings me right to the next slide. Oh, skipped it, go back. Yeah, there we are. So this is my quick map. And by the way, I should have said this before. I gave a webinar actually exactly a year ago on the history of official languages in Canada, and it's on YouTube under the QCGN channel if you want to read it. But I go in more detail about the history of language rights in Canada, and I would also recommend watching Graham Fraser's webinar, which was also hosted by the QCGN around the same time last year, which is also on YouTube, if you want to go into more depth about the Official Languages Act, what it is and how it's evolved over the years. But here's my very quick map to how often the OLA gets amended. So it was created in 1969 during a what the Royal Commission on Bilingualism and Biculturalism called the greatest crisis in Canada's history, having to do with national unity based in language. It was overhauled once in 1988, a big constitutional year for Canada, also following the Canadian Charter of Rights and Freedoms had to implement some new language rights that came out of that. But that was a big moment, a tumultuous time in Canada's national unity story, let's say. It was then amended one other time in 2005 to add one clause in Part 7. That's important, but it wasn't a major overhaul. And now here we are in 2021, 2022, with a proposed overhaul that is on the scale of what we saw in 1988. So the question I ask myself is, well, what's going on constitutionally that's causing this to happen? But I'll leave you with that question. Next slide, please. Back. It always skips 2 slides for some reason. Thanks, Stephen. Okay, so now we'll get to C-32, and I also gave a presentation on C-32 last June at the QCGN's annual event. I'm not sure if that's posted online. So I will review a little bit about what we saw in C-32, because spoiler, C-13 is a lot like C-32. It adds a few things, but it's basically a revision of C-32. So I present this in 4 chunks: preamble and purpose, positive measures, private businesses, and policing, my 4 Ps. So very briefly, in preamble and purpose, we saw the Act retained its basic framework and purpose. Nothing was deleted, but something was added. And that add was this sort of turn toward the protection and promotion of French specifically. So we see this as the first break with the symmetry that we have in the current Act. So it's a recognition that French is a minority language in Canada and North America. So this was a recognition, but also came with some specific policy purposes attached to it. And there was also a new recognition of the, oh, can you go back? Back. Yeah, there we go. Thank you. There's also a new recognition of the diversity of provincial and territorial language regimes, which I'll talk about a little bit when we get to C-13. But this raised some eyebrows because it included a recognition of the Charter of the French language that was going to be written into the Official Languages Act. The second thing on positive policy and positive measures. So we saw an overhaul of Part 7, which is the part that provides support to OLMCs, among other things. And again, it added this recognition that French is in minorities in Canada and North America. It added a lot of additional detail into Part 7, which looks a lot like what OLMCs asked for in terms of spelling out more detail to make it more enforceable. But at the end of the day, I wasn't convinced that it actually added any new legal obligations on the government. Yeah. It also included a clause on federal provincial cooperation that again referenced the Charter of the French language, and that also caused a lot of eyebrows to be raised for English-speaking Quebecers, not knowing if that's going to cause some constraints or blockages on the federal support that would be available to the English-speaking minority in Quebec. On private businesses, we saw the addition in the Official Languages Act of itself of 2 huge new parts, chunks of the Act that were going to create what looks a lot like the Charter of the French language light in federally regulated businesses. And I'll get to this when we talk about C-13 because we see it again, albeit in a slightly different version. And then policing of the Act, we saw a really beefed up role for the Commissioner of Official Languages, also an enhanced role for the Minister of Heritage and Treasury Board, where they kind of share responsibility for different parts of the Official Languages Act. But the big structural problem that the OLMCs had identified, which is that there's no one central agency overseeing the whole Act, it remained in C-32. That problem was not fixed. What we didn't see, what we were looking for, but didn't see in C-32, as I said, a centralized authority for the Act. We didn't see any changes to Part 4, 5, and 6, which had to do with services and work in the federal government and services from the federal government. And we didn't see any new clauses for accountability in federal provincial agreements and linguistic clauses, which OLMCs have been asking for. So when federal and provincial sign an agreement in any sector, are there protections in place for the official language minorities? And when they sign an agreement for official languages support, is there any accountability for that? Or does the money just go from the Fed to the province without any accountability towards the OLMCs that are supposed to be the beneficiaries? So the big questions that we had after that experience were, first of all, where does this leave the scope of rights for English-speaking Quebecers? The government at the time said that the rights of English-speaking Quebecers are unchanged by this act, but that it raised a question. And secondly, add Bill 96 and stir. What happens with these with language framework, and particularly these references to the Charter of French Language, when you add in Bill 96 and what that does to the Charter of the French Language, what's going to be the effect? So these are questions we had. Next slide, please. Okay, so now I have my color coding system where orange is Bill C-32 and blue is, okay, what's changed in C-13? So as we see here, for purpose and preamble, I say mostly the same. Policy and positive measures, some changes, and I want to talk about them. Third, private businesses, same obligations, but in a separate act. And fourth, policing the act, mostly the same, add some penalties. Still no changes in Part 4, 5, and 6. Still no new accountability in Fed-Prov agreements. And as for central accountability, we see some improvement. So I'll go into a bit of detail on each of these things. Next slide, please. Okay, this is where we start reading legislation. You don't have to read it. I can just tell you what it says. So for preamble and purpose, as I said, it's mostly the same as the changes in C-32. We see a few tweaks in the preamble and purpose. The stuff on this slide is actually all the same as C-32. So in the preamble, we see a recognition of French in a minority situation. We see a new commitment of the Government of Canada to protecting and promoting French. And we see recognition of the quote, diversity of the provincial and territorial language regimes, with a specific mention of the Charter of the French Language, alongside a series of other constitutional obligations. I noticed that this is the only reference to provincial legislation in the proposed bill, which I think is interesting, because there are a lot of other provincial laws in other provinces that deal with the protection of French and French services, but they're not referenced here, only the Charter of the French Language. So this is what we love to call asymmetry, because it's a differentiated treatment of French and English, and it's also a change in referring to specific provincial and territorial regimes. It seems to be raising the question of, well, is this federal law going to apply differently in these different provinces and territories? Another way of understanding asymmetry, according to the way the bill has been presented, is that it's substantive equality. So French is a minority language. French needs additional protections. So it's ensuring the substantive equality of French as alongside English. There's different ways of describing it. Next slide, please. Oh, I should have said at the end of that slide, there is that's my fault, Stephen. It's that there's an ongoing recognition of English-speaking Quebec. So the act right now recognizes English-speaking Quebec as an OLMC. C-32 continue that recognition, and C-13 continues that recognition as well. These new things about French are adding on to the existing framework. Okay, thank you. Next, okay, now we're at policy and positive measures. So this is part 7. This is the part 7 overhaul. It keeps most of the overhaul, and yes, we're heading back into construction season. So here we are. It keeps most of the overhaul that we saw in C-32, and it actually just adds more stuff. So in terms of the government, so the way part 7 works, I should back up. The way part 7 works is that it declares the government's commitment to a certain things, and then it says the government must take, or all federal institutions must take positive measures to implement these commitments. So there's this language around commitments, and then there's language around positive measures. And both of these have been significantly expanded in the new bill. So for commitment, the first thing, largely we see the same new commitments as C-32. So it has to do with fostering the full recognition of English and French. That's in the current OLA. Protecting OLMCs. That's in the current OLA. Now they're supposed to do that in taking into account their uniqueness. That's new qualifying language. I don't quite know what it means. New commitment, protecting and promoting French. New commitment, creating opportunities for learning in the minority language. And new commitment, enumerating rights holders under Section 23 of the Charter, which I won't get into. So expanded number of commitments. In the positive measures, so there's new language in C-13. Well, first of all, C-32 and C-13 both expand and describe the types of positive measures that federal institutions must take, well, it says federal institutions must take positive measures. And here's a list of measures that they may take. And it lists them, things supporting sectors, and new detail, etc. But they're not required to do any of those things. They're just like a list of ideas, things that they could do. New in C-13, positive measures shall be concrete. Okay. Again, good new detail, but what enforceability does it have? Of some concern was the language in C-32 and new language in C-13 now about positive measures shall respect the necessity of protecting and promoting the French language in each province and territory. So how does that filter through to English-speaking Quebec if positive measures, so federal support that comes to Quebec must respect the necessity of protecting and promoting the French language in Quebec? Does that change what's available to English-speaking Quebec organizations? And new in C-13, also, they must respect the necessity, I'm reading from the bottom of my slide here, the necessity of considering the specific needs of each of the two official language minority communities of Canada, taking into account the equal importance of the two communities. Whew, a lot of words, unclear who this applies to, and unclear what effect this would have in English-speaking Quebec. My kind of lens that I see this through, or the whole Part 7 overhaul, is, first of all, have we beefed up the obligation on federal institutions, or has it actually been watered down? And I'm still on the fence, to be quite honest. We see there's some new consultation requirements that have been added in, which seems to be a good thing. There's more detail on the analysis that federal institutions have to undertake under Part 7, seems to be a good thing. But then it says that institutions shall take these positive measures based on, quote, the analysis that the federal institution considers appropriate. So it really seems to be this internal procedural obligation rather than something that a court could ultimately review. And Stephen, if you can go to the next slide, I'll show you the language that really intrigues me, which is that in the general statement of the requirement to take positive measures, there's a new language added in C-13 that wasn't even in C-32 that says this is the general obligation. Every federal institution has the duty to ensure that, it used to say that positive measures are taken to implement the commitments. And now it says that the positive measures it considers appropriate are taken for the implementation of commitments. And the reason I really question this new language is there was just recently a federal court of appeal decision that really gave some teeth to this same clause in the current OLA and said, yeah, a court can review this and a court can decide whether the institution has actually taken the sufficient amount of positive measures. This was a huge win for official language minorities. But I wonder if the addition of this language that it considers appropriate kind of guts that decision of its meaning. That's the question I have raised. So at the end of the day, Part 7, it's more detailed. There's more of it. It creates a lot of new procedural obligations, but at the end of the day, I'm not sure whether it's any better than what we have now. Next slide, please. This is the last slide on Part 7. You don't have to read the text. What it says is there's federal provincial cooperation is important with this federal support. So it's going to be a lot of federal provincial bilateral deals. And that's important. And we must take into account the difference in federal provincial regimes on language, including a specific reference to the Charter of the French language. Now, as English-speaking Quebecers, you all know that the policy objectives of the government of Quebec are different from the policy objectives of the government of Canada when it comes to official languages. So this raises some eyebrows. Next slide, please. And then these things just don't fit into my 4 Ps framework. But in C-32 and 13, we see a new requirement that all Supreme Court judges are to be bilingual. This has been the policy of the current federal government since they were elected, but it's never been a legal requirement, and it's proposed to be a legal requirement now. And there's also I would say the mention of the Court Challenges Program as something that the Minister of Heritage may support. The Court Challenges Program already exists, but it's not a legal requirement for the government to fund the Court Challenges Program. So that the ask was made, could this be written into the OLA, that this program must exist? And what's been written in now is that the minister may fund the Court Challenges Program. So legally, I don't see much difference from the current state of affairs, but it's in there, it's mentioned. Next slide, please. So federally regulated private businesses. Whew. So with C-32, we saw written into the Official Languages Act a whole separate regime to govern the use of French in federally regulated private businesses. So this was huge in the history of the OLA for at least 2 reasons. First of all, it created language rights for French, but not English, in the Official Languages Act. So that was a complete break with the symmetry of the act. And secondly, it was to apply in Quebec and eventually perhaps also in regions outside Quebec with a strong Francophone presence. But it was a regime in the OLA that only applied in 1 province. So this raised a lot of eyebrows. The QCGN was consulted in the lead up to this, and they expressed their opposition to the whole framework, the whole idea of doing this, because of the asymmetry. Anyway, we see it again in C-13, but as a separate act. So it's not going to be in the OLA itself. It's going to be a separate act, aptly called the Use of French in Federally Regulated Private Businesses Act. And in a nutshell, I call this kind of Charter of the French Language light. So what is it? Okay, go back, please. It creates the right to services in French, the right to work in French for employees in these enterprises, and what I call a Francization light regime, which is that the businesses have to foster the use of French in the business. It's a lot less onerous than the current Charter of the French Language, and a lot less onerous than Bill 96. And do recall that Bill 96 itself purports to apply the Charter of the French Language in these same businesses. So we're seeing kind of a convergence on these businesses. And also in this act, the federal act, the businesses have the choice whether to choose to be subject to the federal act or to the Charter of the French Language. And that's a very new thing in Canadian federalism, to give a business the choice to which law they want to be subject to. But that's what it is. Okay. Next slide, please. Finally, policing the act, my 4th P. And I'll go quickly here because there's a lot of material, a lot of detail, but not very much that's of pressing interest compared to what I've just talked about. So this is C-32 added in a bunch of new teeth to the act, and this one takes them up as well. We see new powers for new responsibilities for the Minister of Canadian Heritage, and new role for the Treasury Board. New in C-13, the Treasury Board shall create policies for the implementation of certain parts, 4, 5, and 6, I think, and 7, certain parts of Part 7, And this is of great concern to the Francophone oil MCs. One of their biggest asks during the modernization process was to get a stronger role for a central agency in administering the act so that it would actually be implemented properly throughout the whole federal government. C-13 goes some way towards this, but it's not fully fixing the problem that they identified. Also, the Commissioner of Official Languages is given up a beefed up role in investigating and new in C-13, the Commissioner can impose administrative monetary penalties on Crown corporations and other private corporations subject to Official Languages Act, which is code for Air Canada. Because as we know, Air Canada is one of the biggest offenders of their Official Languages Act obligations. And that's all I wanted to say. Just by the way, we still don't see anything in Part 4, 5, and 6, and we still don't see any transparency in federal provincial agreements. In fact, I think we see the opposite in that reference to federal provincial cooperation and the Charter of the French language. I don't think that that's going to give us any more transparency, quite the opposite. That's, I think, the end of what I was going to say. So now I think I'll hand it back over to Stephen. I'm happy to take questions.
Great. So thanks very much, Marion. Appreciate it as always. We got a few questions during during the presentation, which I'll just address now. First of all, what is the QCGN's position on C-13? Excellent question. We're in the process of figuring that out. Today's presentation, as you know, is simply a technical briefing on our initial analysis of C-13. Marion and I and others are in the process of doing the deep dive on it and preparing the briefs for the committees when it goes into committee stage. So this is part of our process to collect community feedback on C-13 to help the community understand what C-13 is. And then we're consulting with our board, we're consulting with other folks, other leaders in the community on what they think of C-13. But understand the C-13 isn't there's not a lot of distance between C-13 and C-32. And the QCGN very definitely had a position on C-32, which I would encourage you to go and look at. It's on our language rights page on our website, and one of my colleagues can post that in the chat. There's all kinds of great information there. Somebody asked about some of the studies that we use, some of the objective studies that we use. Those are also there on our language rights page. For example, the studies out of the OQLF, an important study by the Industry Canada in 2013 on the use of French in federally regulated businesses in Quebec. So there's all kinds of information there on that language rights web page. I certainly encourage you to go and have a look. There was a question about the QCGN supporting French in Quebec. I just want to be very clear. From 2013, the QCGN statement of principles that the QCGN respects French as the official language of Quebec. That's our position on that the board adopted in 2013. So that's that. There was a question from Catherine. Will C-13 affect the use of English in the courts? No, but the use of English in the courts could be affected by Bill 96. So I would encourage you to read our brief to the National Assembly on Bill 96, again, available on our language rights webpage, and that's all explained in there. Ruby asked what our biggest concerns are with C-13. Again, it's not my place to say definitively what the QCGN position is on C-13, but I can explain what the QCGN's concerns with C-32 were, and C-32 is very close to C-13. From 60,000 feet, our concern is that there is the way that the bill is now designed and is turning towards the protection and promotion of French, and the inclusion in a federal act of recognition of the Charter of the French language in the same sort of place where they're talking about other constitutional documents. We're very concerned about the effect of C-13 on the interpretation of language rights going forward. We're also very concerned in the Act, Marion covered it, there are two concepts now being proposed for the Official Languages Act. One concept is that there are two linguistic minorities in Canada, and this is new, right? Francophones, French being a minority language in Canada. This is a new idea. And at the same time, coexisting with that are official language minority communities, which is in Canadian constitutional history and in the law right now has always been understood as being provincial in scale. So the English in Quebec and the Francophones in the other provinces, because that's the majority language. That's very concerning. It should be concerning for the Francophone minorities as well, because under that idea, the Francophone majority in Quebec could be considered a minority. And what does that mean for the application of Part 7 and the action plan and those sorts of things? We are very concerned that because C-13 for the first time in modern Canadian history that I can think of, actually this is Confederation that I can think of, the federal government is creating language rights for one official language and not the other in regards to federally regulated businesses. And they're doing it supposedly to protect and promote French. What does that mean? So, you know, we're in new ground here. Literally, the whole idea of language rights in Canada, which is pretty fundamental to how we're structured, is being twisted and turned in a way that is in a way that's new and it's not well understood, and that's what we're trying to figure out now in our analysis. Okay, so there is a question there on what's the best way for individuals to affect or to monitor C-13 and maybe affect change. The absolute best thing you can do is to continue monitoring our language rights webpage on C-13. What is the QCGN's plan? I alluded to it, and I'll just explain it in a little bit more detail. So we know we think we know right now what the problems are with the problem areas are with C-13. We think we've identified areas that we might be able to, common areas that we might be able to work with the Francophone minorities to change in Bill C-13. Once the bill passes second reading in the House, which should be within the next little bit, it will go to committee. It will go to the House of Commons Standing Committee on Official Languages. The QCGN will go there. We'll present a brief. We'll present recommendations to the bill to make the bill to protect our interests as English-speaking Quebecers. Lang will then write a report. That report will then go. Sorry. The bill will then go back to third reading in the House, and we'll go over to the Senate. And then the whole process starts again in the Senate, right? First reading in the Senate, it goes to OLO. So unless there's something unforeseen, this bill is not likely to get passed for a while. And there should be lots of opportunity for public consultation. Of course, the QCGN will be is open to ideas on amendments to the bill, and we will be making that public. I'm just going to check something here.
Stephen, while you're checking, I've been scrolling through the chat, and I did see a few technical questions that I could address.
Sure.
So one of them is, how likely is it that federally funded private businesses in Quebec will opt to follow the OLA or the Federally Regulated Businesses Act and not the Charter of the French Language? So I'll just speculate. I don't know. I'm not an expert on private businesses. I can definitely say that the FRPBA, the federal act, is a lot less onerous. I can also say, and Stephen can confirm, that a lot of federally regulated businesses are already complying with the Francization requirements in the Charter of the French Language and have received a Francization certificate from the OQLF. So some of them may be quite happy to be subject and are already complying with the Charter of the French language. So those are the sort of enjeux that I'm aware of. Another question is, can the commissioner impose penalties without a full hearing? Currently, commissioner investigations are conducted in private. That's a really good question. I think that's from Janice Neymar. I haven't looked super carefully at the new procedures that the commissioner must follow before they, but I can tell you that it's quite different from what we see in Bill 96 in terms of the administrative powers of the OQLF. So I see a lot more procedural safeguards in the OLA commissioner's role than I see in Bill 96 with the OQLF. But as to that specific question, I don't know the answer actually. But I will say when the QCGN put forward its modernization proposals back in 2018, the QCGN proposed that the commissioner not receive new powers to sanction because that would make the commissioner sort of a judge, jury, and executioner role rather than a watchdog and cheerleader role, which is their more known role. In fact, we suggested that be given to a different body, maybe a tribunal, but that's not what happened. But I can say there are procedural safeguards for the commissioner that they have to follow. Another one, why are the federal legislators taking an asymmetric approach? Couldn't their objectives be reached with a symmetric approach? So the answer about why, or the stated answer, which we saw in the policy paper in early 2020, which is this concept of substantive equality, which is a concept we see in equality law. So section 15 of the charter, this idea that treating unlike things the same way is not equality. In fact, you have to treat unlike things differently. So for example, in the context of equality law, giving maternity benefits that favor women actually helps to overcome a hurdle that women face that men don't face, for example. So applying that same concept of substantive equality for the first time in the realm of language rights, and hence differential treatment for French because it's a minority language. That's the rationale, that's the policy rationale, that's the legal rationale. That's where the concept comes from.
I just wanted to I just want to rest on this idea of asymmetry for a sec, because there's another question that's come up about it. I want to be very clear that asymmetry as it applies to administrative discretion in the application of the law is a fact. So if you look at the Government of Canada's official languages strategy, which right now is called the Action Plan, conservatives call it roadmaps, liberal governments call it action plans, $2.1 billion over 5 years, but $1.1 billion available for programs for the communities over 5 years, and governments over 5 years. The Quebec gets about, for the programs that English-speaking Quebec is eligible for, we get about access to around 20% of that money. So we're Canada's largest linguistic minority community, 1.1 million people. There are more English-speaking minority in Canada than there are Francophone minorities, because they're now down around 900,000. But the vast amount of the money goes to Francophones outside Quebec. Now, there's a lot of good reasons for that, and I'm not arguing about the reasons, but in the way that the Act is administered right now, there already is asymmetry. So the question is then, why would you have to put that into the Act? Why would you make that legal in the Act, or actually bake it into the legislation? That is a significant concern to us. Somebody asked if we're working with MPs. We are absolutely working with MPs and getting a lot of support from Anthony Housefather, Patricia Lattanzio, and other members of the English caucus from Quebec. They are being very, very helpful. Somebody asked a question about C-13 and CEGEPs. CEGEPs are an area of provincial responsibility. C-13 does not affect admission to CEGEPs at all. Sorry, Mary.
Thanks, Stephen. I was going to address that question. Does C-13 affect education? So Stephen's right to say it doesn't change the legal framework for CEGEPs and what's happening, but C-13, as the OLA currently does, provides a framework for federal support to minority language education. So primary and secondary education, particularly in Quebec, is partially funded through federal support. I had a few other questions I wanted to pick up on. Should I do that? Yeah. Yep. Okay. Is it unusual for federal legislation to specifically reference provincial legislation, as is the case happening here with the Charter of the French Language? Great question. It's not unheard of. Sometimes federal legislation can A, apply in only one province, or B, incorporate by reference legislation from particular provinces. So it's not totally novel what's happening here. But as I said, what I find interesting is that it's only referencing this one provincial statute and not all the other ones that deal with the French language. Someone asks, are the protection of French language rights compatible with the protection of English minority rights? That is the question that we are all asking. My view is that yes, they are. And in fact, I think that the Official Languages Act currently is an example of that. It's about the protection and promotion of both official languages. And as Stephen said, in the implementation of that act, there's a concept of substantive equality that applies. So for example, federal support should go where it's needed to address the problems that exist and the challenges that exist, and the communities themselves should be involved in designing and implementing those programs. So I think there are lots of ways in which the protection of the English-speaking minority in Quebec is compatible with the protection and promotion of French in Quebec and the protection and promotion of French outside of Quebec. It's just a question of structuring the framework properly. Okay, those are all the questions I picked up.
Okay, it's getting close to I guess 1 o'clock your time. So I just want to thank Marion very much for coming today and helping out with this technical briefing on C-13. There's obviously a lot of interest in the new federal legislation. Like I say, the QCGN board will be finalizing our organization's positions on C-13 over the next few weeks. And you'll expect to hear from us more on this act. In the meantime, please do monitor our language rights page on our website. If anybody has any follow-up questions on Bill C-13, I'm just going to put my email in the chat. Please feel free to reach out to me, and we'll do our best to answer your questions. So thanks again, everyone, and Marion, have a great day.